Yeah, today we are going to touch on something different. We are going to touch on the civil rights and the offenses for every trademark owner. And before I move on, I would like to introduce myself. My name is 𝐔𝐧𝐿𝐴. I am the CEO of Trademark to You. I'm a patent agent. I'm a trademark agent, and I have served this industry for 22 years, since 2002. Trademark to You, we are established in Malaysia. We have a branch office in Thailand, Indonesia, and also one office in China. So serving both international and local clients. So today, I would like to thank everyone for participating, for taking your time to come and join this webinar. And I hope that one day we can actually organize one offline seminar, right? And I hope to invite everyone to come and participate for maybe for a half day or 1 day seminar, so that all participants would have the opportunity to interact among themselves. Do you agree on that? If you agree, just give me a raise up your hand or clap your hand, whatever indications. Okay, let's give ourselves another few more minutes. Okay, can you all, if you like to, make yourself comfortable by getting your cup of coffee, tea, snack, or whatever, please go ahead, because nobody is watching you. This is a hybrid webinar, and this will take around, I will estimate about 1 hour, kind of lectures and presentations. Now, at the end of the lectures, I will go slide by slide, okay? I will start in 3 minutes time. And before that, I would like you to actually download the slides. Okay, you can actually download by scanning the QR code here. If you see on my left side, which is I think your right side, there's a QR code here, and you just have to scan it, okay? And then you will download the PDF copy, okay? And before I start, I would like to put on a disclaimer that nothing in this video, nothing in this webinar can be used, okay, as a reference, all right? And I have tried my best to make sure that all the facts and information are accurate. Now, in the event if something is wrong, please forgive me, all right? And please excuse me, and do not use this video as a reference. Okay, this is a disclaimer. And you may get yourself a trademark act one day, or download from myipo.gov.my. It will actually spell out all the requirements, all the legal requirements inside. So, yep, I think everyone should keep one trademark act, at the end of the day in your office. You can put in the decorations or whatever you want, but you should have one copy of it. So because the trademark is very important. Okay, I think it's almost 5 minutes. So much for ice breaking, and I think we should start now. Okay. So welcome to IP seminar. We are going to discuss something on trademark legal remedies, offenses, and enforcement in Malaysia pertaining to Trademark Act 2019. Okay. So at the end of the lessons, the outcome of the lessons, you will be able to understand and to explain the trademark infringement procedures and remedies for trademark infringement actions in Malaysia, the Malaysian trademark offenses or offenses related to trademark, okay, and corporate responsibility, whether corporate people are equally liable for the trademark offenses, and the trademark enforcement authorities, okay. So this will be based on the Malaysian Trademark Act 2019. It's a quite recent amendment, a new act, which replaced the previous act. So now, let's start. Okay, let's start with the civil litigations. So under the Trademark Act 2019, for trademark infringement, okay. Section 54, a person infringe a registered trademark if he uses a sign which is identical with the trademark in relations to goods and services which are identical with those for which it is registered proprietor. So let me just clarify one thing. If you can see the QR code here, you can scan at any time along my presentation, during my presentations, so you can actually download a copy, for yourself. It's free copy. I done it. Okay, it's a free copyright. So, but don't just keep it for yourself for your own reference. Okay, don't. You can share it with your friends. It's okay. Now, Section 54 empower the registered trademark owner to sue anyone for infringing his or her trademark. Okay, that is the core and the root of your rights. So next time, if people challenge you and you are a registered trademark owner, you just say that under Section 54, I have the right to do so. Okay. Now, what is an infringement here? A person infringe a registered mark if without consent, listen carefully, without consent, written consent from the proprietor of the trademark, uses in the court of trade a sign. Now, the sign here means the trademark, which is identical with your trademark or similar to the trademark. The trademark here means the registered trademark. Okay, and is used in relation to the goods similar or identical to which the trademark is registered. So you see here, you need to fulfill two things here. First, there must be a without consent. Okay, without consent. And then if you use in the course of trade, and then which the mark is identical or similar, and also quite similar or identical to the list of goods that you apply for. Okay, and result in the likelihood of confusion in the part of the public. Now, when you join our next seminar, the next 2 weeks time, probably by end of this month, I will actually do some case law studies over trademark infringement, over some of the issues about public confusions here. The whole idea is that public are confused, with these two marks, and they thought that these two marks will belongs to the same owner or something like that. So that is the whole idea of Section 54. Now, Section 54.3, the Act actually spell out in what situations there will be infringement. So a person uses a sign, a mark, if it apply the mark to the goods or their packaging, that is one situation where there is a trademark infringement. Or expose an offer for sale. Yes, that is also another way of a trademark infringement. Put the goods on the market under the sign. You try to, offer for sale, whether it's through, through online marketplace like Lazada or Shopee, or maybe you put in any hypermarket. Yes, that is infringement under 54.3. Okay, import and export of the goods under the sign. Under the sign means using the registered mark. Okay, that is trademark infringement. And this is a civil case. And use the sign in advertising. So, or uses in any catalog, business, or whatever. So that is the qualified under this, what you call it, trademark infringement things. Okay. So, okay. Now, let me explain. Under Section 55, there are certain situations where the acts are not amounting to any trademark infringement. So the first thing is that a person does not infringe a registered trademark when he uses in good faith. In good faith means in good faith lah, okay? He didn't intend to use it for commercially, and he used in good faith, okay? So if I mention, all right, this is the mobile phone belongs to Samsung, so I'm not infringing because I'm using it in good faith. And he used in good faith to indicate the quality, the quantity, intent, purpose, or the character of the goods. So as long as the person uses the trademark in good faith, then it should be all right, okay? That's situation number one. Situation number two, acts which are not amounting to infringement. Now, this is very important, yeah. A person does not infringe a registered trademark by using an unregistered trademark that is identical or similar to the registered trademark in relation to goods or services, blah, 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 okay, which the trademark is registered if he has or his predecessor in business have continuous use in the course of trade, the unregistered trademark from a time, look, when I highlight the word from a time, A, before the date of registration of the registered trademark. Now, if I uses the trademark, let's say this trademark called Alibaba, I've been using it for many years, maybe 3 years, 5 years, even before the date of the registration, and somebody went and actually applied and registered so-called Alibaba. Assume that the trademark is called Alibaba, okay? Alibaba. So someone has registered Alibaba and he's trying to sue me. And I've been using this Alibaba even before he actually applied to register the trademark. So am I entitled to the infringement? The answer is under section 55(2), no. You are exempted from the infringement. If you have been using the mark before the date of registration of registered mark, okay? Or B, the situation is B, the date of registered proprietor or predecessor in the or person who has registered user under the old Act first use the mark, whichever is earlier. Meaning that if you have been using the mark continuously, even before the date of registration, okay, then you might be exempted, okay, you might not infringe this registered mark. So then you will ask me this question. Then what's the purpose for me to register the trademark? Simple. If you do not register your trademark under section, as I said earlier, 54, you do not have the rights to sue somebody for trademark infringement. Now, what if that person registered your trademark and you have been using it for many years, but he registered it because no one want to register it, he registered it. What is his rights? Now, he is still a registered trademark proprietor, and under section 54, he is entitled to sue anybody who uses the trademark except you under section 55(2). Okay? I hope you understand this, my point of view on this section 55. So let's move on to another third situation. Section 55(3) of the Trademark Act. Now, a person uses a registered trademark does not infringe a trademark if he uses it for non-commercial purpose. Okay? Now, there's a trick here. There's a trick here. Someone will tell me, hey, Lawrence, I want to use the big brand, let's say LV, okay, Louis Vuitton, okay, Louis Vuitton. So I want to use the big brand, and then I want to put on all the plastic bag or whatever nice bag. I want to do charity. I'm selling it to charity. I'm not making I'm not making money. Okay, and is it fall under this non-commercial purpose? The answer is wrong. No. Okay, as long as there's a trade in exchange for any benefit in kind, that is commercial purpose. All right, even though your purpose might be for charity purpose, but it's still commercial purpose. Non-commercial purpose means like when you do your research, when you're doing news reporting, and then you maybe came across certain brand that you want to do some reporting, okay? So that is using in good faith, and then there is non-commercial purpose, all right? And of course, number C, at any time expressly or impliedly consented by the registered proprietor. Of course, if the registered proprietor consent to your usage, of course, there won't be any infringement. But please put out in writing, no verbal consent, okay? Written consent. Okay, so all right. Section 55(4). Now, there's one more situation is that a registered mark is not infringed by the use of another registered mark in relation to goods and services for which the later is registered. So if you have two similar marks and both actually similar mark were registered registered according to the trademark registry. Can you sue the other guy for infringement? The answer is you need to expunge. We call it expunge. It means you need to cancel the rights of the other party, the later party. And if the court think that, yes, they need to cancel off first, expunge first, before there is any infringement took place. So basically, you cannot sue somebody who has a registered trademark for trademark infringement. That's the one good thing about registering your trademark. So you register a trademark is not to sue somebody, but to protect yourself against any possible trademark infringement. Is the mic okay? Can you check, double check? And can you hear me? Because wait. Anyone can hear me? Please raise up your hand. Should be okay, right? Okay, yeah, okay, I saw the hands. Because I'm just afraid because sometimes the webinar, the indication is not there. Okay, thank you so much. Now let's talk about the legal remedy. So what rights a trademark owner possess if I'm a registered trademark owner? I mean, on the civil side. So Section 56, actions for infringement. Registered trademark owner has the right to institute court proceeding against any person who infringed or is infringing the trademark. Okay, Section 56(1), 56(2), likely that an infringement will occur. Now, 56(2) is a preemptive strike. Okay, if your actions, if you are, what do you say? Let's say you are actually making a sign, using the infringed trademark, registered trademark, and you're supplying that infringed trademark sign to another party, maybe your OEM supplier or whatever, yes, you will be liable as well, because that it will be a likelihood that an infringement will occur if you have this kind of conduct. Okay, so Section 56(1), 2 actually spell out the rights to sue, to institute court proceeding against anybody. Okay, so what rights I have? 56(3), I can actually, the court can actually grant an injunction. If you have a registered trademark, the court is likely to grant an injunction to stop someone from continuing infringing your trademark. However, it's not that easy because the court have to justify at the end of the day whether to grant the injunction or not. Okay, so perhaps the court will ask the trademark owner to put some deposit in the court as before they grant the injunction. Now the court can award damages. Okay, damages, and also accounts of profits. Now, damages can be any damage, the past damage done. Accounts of profits you can actually the court can actually award the profits, accounts of profits for the loss of profits, etc., etc. Okay, so wait. Now 56(7), if a person was caught for counterfeiting the trademark. Counterfeiting using a counterfeit trademark. Counterfeit means I make exactly your registered trademark, and that's counterfeiting. So the plaintiff, at his own choice, he can actually sue for damages and account of profits. Okay, or accounts of profit or additional damages besides the general damage, besides the account of profits, and maybe other damages, maybe other additional damages if the person thinks fits. All right, but you can only claim, from the date your trademark has become registered in Malaysia, not before. Okay, from the date And our legal date, actually, sorry, you can actually claim for the infringement any prior to the date of applications and is made and become registered. So you see, our trademark, you may apply today, but you may not get tomorrow. So it might take you maybe 1.5 years to get it registered. So when is that actually the legal date? When is the legal effective date? It's from the date of your application of the trademark. So if you have not registered, have not applied for the trademark, please do it as soon as possible, because the legal effective date actually counted from the day of your applications. Okay, not the registration date, the application date. All right. Now, we have other actions for infringement, such as we can also apply for order for erasure, or to erase off the offending sign. The court may actually make an order requiring the person to actually erase, remove any offending sign from the material, etc., or to destroy the so-called infringed trademark. Delivery up. So this one, what's in your mind? You would think of Grab, right? Or any delivery courier service company. No, the court actually can grant an order that any infringing goods material to be delivered before the court to be destroyed. Okay, to be destroyed. So that is delivery order under section 59 on 60s. Okay, this is, I hope everyone will pay attention on this, because a lot of clients, they came to me and said, hey, Lawrence, can you help me to write a letter and to sue somebody for infringing your trademarks, something like that. So the first question I would ask is, I would check whether your trademark has been registered. Okay, and also you have to check whether the other party actually is using identical or similar marks. Now, see, there's a problem here. See, section 61. Where a person threatens another with proceeding for infringement of a registered mark, okay, other than the goods used for the mark, other than suppliers of service. That means if you try to threaten anyone without a valid cause, now this is what's going to happen. That aggrieved person may bring proceeding for relief under this section. That means that, hey, you don't simply send letters to other people and threaten them to sue them. Because if you, people say, if you haven't 搞清楚 or haven't clarified the facts, and you want to sue them like that, they can actually bring a countersuit, an action against you for this, what they call it, groundless threat, okay, under section 61. Those days, before 2019, the new act came in, a lot of clients, they like to send letters, threaten to sue. You have violated infringed my trademark. I want to sue you. Whether it's true or not, they still want to sue you first. So now you cannot do that. You cannot simply write a threatened letter to sue. All right, because the relief, the other party can get a declaration that your threats are unjustifiable. They can get an injunction to stop you, and also they can ask for damages from you if you do that. Okay, that is section what they call it, 61(2). Okay, 61(2). Unless the defendant show that the act, this threat is a real threat, because the person indeed uses your registered trademark, and there's an infringement going on. So then only you can actually send a warning letter to say that I'm going to sue you if you continuously using infringing my trademark, my registered trademark. Okay, that is fair. Okay, but you have to prove it. If you don't have such proof, better you have to be careful when you issue any warning letters. However, just a mere notification. Can I just notify them that my trademark is registered? Yes, you can publish on any newspaper. You can write them letters, love letters, whatever, and you can just say that, oh, this is to notify you that my trademark is registered. I reserve the right to sue if anyone infringes my trademark. Yes, no problem. That one you can do it. Go ahead. Okay, and be careful, because under these sections, the beautiful thing is that the law actually exempted the lawyers, the advocate and solicitor, to be liable under these sections. So if you ask your lawyer to send any groundless threat letters to third party, the lawyer will happily do it because you pay them money. But is he or she going to be liable? The answer is no. Okay, you will be liable. You might be actually countersued by the other parties, for the so-called groundless threats, okay, of trademark infringement. So please be careful. Okay, we are going to talk about the trademark offenses under the law. Offenses means it's criminal offenses under the Trademark Act, okay, 2019. The first thing I want to bring to your attention is that under the new amendment act, 2019, things have changed. It's not so easy like last time. Okay. Last time, the old act, we don't have counterfeiting, we don't have offenses, we don't have criminal offenses. But the new act, yes. So under section 99(1), anyone who counterfeits a registered trademark by making a sign, which is identical or similar to a registered trademark, or falsifying a genuine trademark, a registered trademark, that is considered as counterfeiting. Okay, that is considered as counterfeiting. So if you were caught, the person can be fined up to 1 million ringgit and imprisonment not exceeding 5 years, or both. So those days we don't have this act, but now we have. So you better be careful. Now, another situation is that falsely applying a registered trademark to goods and services. Now, section 100 spell out that a person falsely apply a registered trademark to goods and services when he applies the trademark a sign likely to be mistaken for the trademark to the goods or services without the consent of the proprietor. Of course, example, if I'm using your registered trademark, I put it in my public packaging and all these things, okay? That is actually falsely applying your trademark. So that is wrong under section 101. Now, section 102, a trademark shall be deemed to be applied to goods or services if I apply your registered trademark and I use it in any sign or advertisement. So example, like I'm using, like, let's say example, Nike brand or some other brands, I design and I put the design in the poster. I say big sales, warehouse sales and all these things. So without the consent of the registered proprietor, I'm actually falsely using other people's trademark. And this is wrong. This can be a criminal, an offenses under section 102. Okay. If you use it in the sign or advertisement, means that any kind of sign or advertisement, any invoices, any catalogs, business price list, etc., etc. Okay, that is wrong. So you cannot simply use other people's sign. Okay. Section 103. Still, we are talking about falsely applying a registered trademark. Now, a sign shall be deemed to be applied to goods if it's applied to the goods themselves. If you stick the logo onto the goods itself, that is falsely applying to the goods. Okay, you apply to any cover label, you try to do a packaging there, that is also falsely applying to what they call it, a registered trademark. Label includes band or tickets. Okay, covering includes a glass, bottle, vessel, and all these things. Okay, all the definition here. So what happened if you were caught, falsely applying other people's registered trademark? Now, for company, for body corporate, including a company, etc., okay, a business entity, you will be fined for 15,000, up to 15,000, not more than 15,000 for each goods. And if it's a second subsequent to the offense, if you were caught second time, you will have to pay the fine less than 30,000 per item of goods. Now, what about the individual? if you were caught falsely applying using this one, you will be fined 10,000 for each goods, imprisonment no more than 3 years, or to both. So this is very serious. You know that the trademark, you see the Trademark Act was amended so that it is a very serious offense now. You can go to jail, okay? If you falsely apply other people's trademark without their consent. What about services? Services example will be what? Financial services. Example, Maybank, example, public bank or whatever banking. Okay, those are financial services. Okay. So if you falsely apply, if you are doing financial consultancy services and you simply takes other people trademark, registered trademark, like example this example, CIMB Bank, Maybank, you put it in your logo, put it in your bunting, all this thing. When you were caught, yes, you will be fined. Okay, a body corporate will be fined no more than 100,000. Your company will be fined no more than 100,000 ringgit. Or if a person is not a body corporate, then the fine will be 70,000 or imprisonment not exceeding 3 years, or both. So you can be fined and you can go to jail at the same time. So serious. Okay, so serious. So you have to be very careful when you don't simply applying use other people registered trademark. Now, making or possessing the article of trademark 101, section 101. This is very interesting because this one, those who actually involving in the business of like selling second-hand bags, example, okay, or selling second-hand items or branded items, watches or whatever, you have to be very careful, okay? If you possess any infringed article or trademark, okay, has in his possessions, you will be liable for counterfeiting, same like counterfeiting, okay? You will be liable for not exceeding 1 million ringgit, imprisonment not exceeding 5 years, okay? Remember the word, I highlighted the word, has in his possessions, okay? Possession. Even though you did not want to sell the thing, even though you want to put it in your office for decoration, but you have in custody, control, and possessions. So that is also an offense under section 101. Okay. Now, what 102 actually define importing, selling, and also with falsely applied to trademarks and also in the possessions. Okay. So A will be importing to Malaysia. Now, if you import, counterfeiting registered trademark items into Malaysia, it is still an offense under 101, 102. Offer to sell and sell. Even though you did not sell the physical products or using whatever physically transactions, but you publish, the fact that you publish offer to sell maybe at one of the online platforms, or maybe like that, it is also an offense under 102. Has in possession custody, okay? That is also under an offense under 102, okay? So sometimes people will ask me, hey, you say about custody and possession, all these things. So what is the definition of custody and possession? So under 102, the Act say, a person has in possession of 3 or more of the items considered to be possessions, okay, for the purpose of trade and services. So if you take 1 item, it's okay. If you take 2 items, it's still okay lah, okay. If you have 3 items, that is considered, in possession of items of goods which are falsely applying others' registered trademark. So if you look at the what they call it, the picture here, those are fake items lah, okay, and you can count how many items you possess already. So if you got time, you do it in your own sweet time, okay. Now, under section 104, what are the offenses for importing, selling, falsely applying a trademark? If you see, let's say if you go to, let's say, another country, overseas country, you bought all these fake item products, and very unluckily you pass through our KLIA customs and someone was there, watching you, and then they said, okay, they have a rights, okay, to actually the domestic trade officers, if they were stationed there, they still have the rights actually to charge you for importing a falsely applied trademark into Malaysia. If you have bought, you might not make the thing yourself, but you bought it in overseas, okay, and you import it to Malaysia, yes, you will be charged, you can be fined. If for company, body corporates, you will be fined no more than 15,000 for each item of goods. So if you have 10 items of goods, you times, okay, how much is it? Subsequent offense is 30,000. So the fine is very, very heavy. And for individual, it's 10,000, and of course, no more than 3 years. Okay. So corporate responsibility and corporate liability, we call it. Especially when some of you, some of the participants here, I know you have several outlets. Okay, maybe you franchise it, you have a JV with other people's, all the outlets, okay, and they're selling products. So now, Section 137 says that the principal will be liable for all the acts of the servant or agent. Okay, so in general, if the servant or an agent of the person committed an offense, okay, and generally the corporate is also equally liable, unless you see, I proved that, unless he can prove that A, the act or omission complaint was not within the ordinary scope of employment of the servant or agency. Okay, so I didn't ask you to sell fake products in the shop, so that is your problem. Okay, because maybe some of your agent, they are very naughty, they don't listen to you, they just bought some fake products and then they sell it there, so you might be liable. They try to bring you into it, so you must draw a very clear scope here. Okay, I did not ask you to do it. So, and the act was done without the consent from the principal. Okay, that one the principal will be excluded. Otherwise, whatever your agent does, okay, the principal will be equally liable. So this is very important, Section 137, yeah. So 138, when the company is liable under the offenses committed by the body corporate, so who are the person who are involved here? So Section 138(1) says that the director, the CEO, the COO, the manager, the secretary, or similar officer of the body corporate, okay, they may be charged severely and jointly in the same proceeding. So even I would say your poor company secretary or your secretary also will be charged also. Okay, when they arrest a body corporate, they charge everyone in the body corporate, such as the directors, okay, and also the management person. Okay. 138, if the body corporate found guilty of the offense, shall be deemed to have guilty for the offense unless he can prove that the offense was committed without his knowledge, consent, or convenience, and the body corporate, the principal, has taken all reasonable precaution and exercised due diligence from committing the offense. Okay. So you have, if let's say, like, I'll give you an example, if you operate a chain, okay, a few store selling second-hand products, you have to be very careful because sometimes people just put, fake items there, or maybe your staff is doing that, we don't know, okay? So if someone caught one of the branch, you also gonna, okay? That's why you have to be very, very careful. 138, any person liable under the Act punishment before this, okay, he shall be liable to the same punishment penalty for every such conduct default by the agent or his employee. If the act, omission on negligence default was committed in the course of employment or acting on behalf of the person, okay? And maybe you can take some time to read off these sections here, all right? Okay, under Trademark Act 2019, the good thing about this act is that there are provisions for criminal offenses as well as enforcement. When we talk about enforcement, it is enforcement under the enforcement unit of the domestic trade, Ministry of Domestic Trade. Okay, so previously we don't have such such acts or such power, okay, given to them. And we have it, but it's under different acts. We call it the Trade Description Act, and there are many problems, you know, when enforcing the Trademark Act. Okay, so now the act has already changed and make it easier. So power of investigations. So section 111, assistant controller, they call themselves assistant controller. Okay, Malay we call it penguat kuasa, but actually the act say is assistant controller or the controller. I don't know why they use the word controller, but okay, since that they like it, they use it. Now, assistant controller, on reasonable ground, he or she may investigate any potential counterfeiting or offenses happening. Okay. So 112. Now today, if you guys come here, this is very important. First, 1121, the first situation is that the assistant controller, upon the complaint by a person, may conduct an investigations, okay, to see whether any person has committed an offense under the act. Now, what happened if sometimes the trademark is similar but not identical? Okay, if it's similar to your registered trademark, but maybe it's not identical. So what you should do, okay? Under 1123, if you found that someone is using a similar trademark to your registered trademark, which is not identical, what you should do is that you can apply for, we call it the registrar verifications. I will explain what is that later in the next slide. Okay, now in the old act, we don't have this facility. If you want to get a TDO, a trade description order, you need to go to the court, which will be very going to spend a lot of money, you know, before you actually can get an order. And it's quite, the court process, you know, sometimes it's a bit delayed. But for registrar verification, it's very simple. We just need to submit the evidence. We need to submit a written submissions, and we have to file in the forms with the payment to the registrar of trademark. He or she, within 2 months period, 2 weeks period, 2 weeks time, will give you an answer whether this so-called infringed mark were actually identical or similar to your registered trademark. So what happened? Let's say if the mark is similar or identical and will cause confusion in the public, you may take the decisions of the registrar verifications and lodge the report with the assistant controller within a year. Now you have 1 year period to do that. Okay, so it's very important because the registrar verifications is a prima facie evidence before any court of law. Okay, because that is very important. That piece of paper, if the registrar thinks that these 2 marks were similar, identical, and will confuse, you have the power. You have the power to ask the SC to arrest and then to take further actions. Okay. So this is one of the example of the decisions, okay, by my client. And then 113 is a public document, so I can share with you. I'm not going to disclose the insight because it's unfair for the other guy. But we managed to get the RV. We managed to, you know, with this RV, it's good for us because we need to threaten, or so-called threaten, or we have to tell the other guy to stop infringing our client's trademark. So this is very important, yeah, 112. Okay, so when you are a registered trademark owner, the first thing you do is that when you found someone infringing your trademark, better call me, come and see me, get some evidence. I will apply the RV for you. Okay. Now let's discuss the power of the assistant controller. Of course, AC, like any police, like a police officer, he can actually call you up for evidence, for recorder of evidence, and you need to submit whatever document required by him. Okay, so the assistant controller may retain documents. He will come to your office. He may actually take some documents with him. Now, what happens if you are giving a false and misleading statement to the officer, the assistant controller? You can be penalized up to 100,000. The assistant controller under section 119 may arrest without warrant. Okay, he may arrest somebody without warrant, but he need to bring the person arrested to the nearest police station. Okay, he cannot bring it to his office or his house. You have to produce before the police station. And the AC, when the AC, the assistant controller, can exercise the power at all reasonable hours, and he can actually inspect by entering any premises except residential services. That means premises used for dwelling. Now, what happens if you keep all the infringed goods in your house? So basically, you need to get a court warrant, okay? A magistrate warrant, okay? So when the AC arrested your goods, he can seal off the premises. He can seal off the container. So you cannot simply break, okay, or tamper such a seal. Okay. Now, magistrate may issue a warrant. So, of course, in certain situations, the AC doesn't want to get involved so much. He or she might get consent from the court, the magistrate, to issue a warrant to cease to investigate, okay, to enter any premise. Of course, that one includes that he has the power to seal off and to remove any document or infringed goods. So can he search without warrant? Yes, under section 122, assistant controller, if he has reasonable ground to believe that the person is infringing, and to get the warrant will delay the investigation, so he may or she may so-called search without warrant. You can enter the premise and do the searching without warrant. Okay? So don't fight with them, because under 131 obstructions, if you refuse to cooperate with them, they can charge you under 131 for assault, obstructing, or hinder delay. So you will be penalized not exceeding 100,000. Okay. I think today's, oh, wow, so early. Okay. We started at 3:30. Yeah. So now it's almost 4:15 or 4:20. It's just perfect timing because I don't want to delay your time so much. Okay, on your right side, on my right side, you can scan and download the slides. And we're going to have another webinar maybe 2 weeks later on the 28th of August, 8 p.m. at night, Malaysia time. So in the next webinar, I hope everyone here, maybe you can ask your friend, or maybe you can bring more friends to participate, because it's a free webinar. And we are talking about the thought of passing off. Okay, the thought of passing off. So you heard of this word called the thought of passing off, and then there you go. You can actually scan here on my left side. You can scan this to register now. Okay, for the next webinar. And for today's participants, okay, 35 of you. I think 35 of you.